this honorable court and other high courts who have attended the functions organized by Adhivakta Parishad, which is a bar association, and spoken on the subjects of law. Please have a look, my lord, page 19. Lord, this is when your ladyship attended. Please have a look, my lord, on the Chief Justice. I don't want to name, and I'm not, my lord, here to sensationalize anything. But please have a look. Then please have a look at, my lord, page 20. Another honorable judge of this honorable court. Would this judge also be disqualified because she participated in a function organized by Adhivakta Parishad, my lord, that is women advocates in the legal arena was the subject. It was not a subject of any particular political party's ideology. Otherwise, no honorable judge would accept it. Then next, please have a look, my lord, one sitting honorable judge of the Supreme Court with your ladyship, and the subject was same. My lord, if my learned friend is serious about this contention, then let him make a statement, especially respondent number 18, that honorable judges who have attended Adhivakta Parishad, the orders passed by them in his case should be recorded. I have no difficulty. Because I don't want to again sensationalize. His bail is granted by one of the honorable judges of the Supreme Court who attended the Adhivakta Parishad. But can this, I'm posing a question to myself, it's, my lord, disheartening that someone has the, my lord, I'll not use any adjective, but someone can even raise this contention. Please, my lord, have a look at the, my lord, luminaries who attend this function, and most of them are, my lord, sitting judges. Complete that. My lord, before that, one more fact. The honorable court's first order dated 9th April, which 9th March, which I would not term as ex parte order because they were served. They chose not to remain present to oppose either issuance of notice or pass any interim order. And the honorable court could have, in law, stayed the order of remand itself. But that remand was not either prayed for being stayed. I'm sorry, not remand, discharge. Discharge. Neither a prayer was made because we also are responsible in making our prayers, nor the honorable court ever considered discharge being stayed. And therefore, whatever interim order is passed is of such a nature that it does not cause any prejudice to them. That all right, no adverse observations against the CBI till the honorable court decides. Until then, finality be not given to ED proceedings. That's the only order. Now, this order, my lord, was passed on 9th March, and immediately thereafter, on 10th March, Mr. Arvind Kejriwal, I'm sorry, I generally don't name the litigants, and Mr. Sisodia, if I'm not wrong, moves the Honorable Chief Justice that please remove this matter from this bench and put it before another bench. The learned Chief Justice passes an order on 13th of March 26. Immediately on the next day, 2 proceedings are filed. Please come to page 3. So that it may not be said that this was not brought to the court's notice. 2 proceedings were filed. A, challenging your ladyship's order of 9th of March 26. Inter alia on the ground that prima facie your ladyships have made some observations. Lord, and I can make this statement without fear of being disputed that whenever the honorable court anywhere in the country passes an interim order, the honorable court will have to say that prima facie it appears that this has happened, and therefore the interim order as prayed or as modified is justified. But they went before the honorable Supreme Court by filing an SLP against that order and a writ petition challenging the order of the learned Chief Justice refusing the recusal application. Lord, when the matter was next listed on 16th of March, the honorable bench would recollect. The time was sought by the respondents on the ground that my 2 proceedings are pending in the Supreme Court. And I had predicted in no uncertain terms that this is my apprehension. They will not remove office objections, will keep it pending because the only purpose they have it might, according to us, and we have said on affidavit, is to delay the proceedings because they know the order is completely undefendable. And that happened. Lord, till date, this SLP challenging 9 March order is kept in office objections. It is in defect. They have not removed office objections, and therefore it has not been listed before the honorable Supreme Court. And now the same arguments are being made that this order is bad, and therefore we have no faith in the court.
He filed a recusal on?
He filed a recusal application on 11th of March before the learned Chief Justice. And my lord, none of the lawyers have said that we were wrongly served. We have already been discharged. My client is also discharged. The relationship is severed, and therefore they have never come before your ladyship and saying they said that this service to me is wrong. It's a technical argument that our lawyers were served, we were not served. And some of them even went to the extent of saying that there is no service at all. Why? Because we were personally not served. So, admittedly, the lawyers were served, and the registry of this honorable court records that the lawyers were served. Now, but kindly directly now come to page 6. Lord, as I have already pointed out, I'm not reading these orders, but these are the orders where whenever the question of validity of any proceedings or order of a predicate offense is under question before this court or before the Supreme Court, since ED is a consequence of that, the court always say that let ED's proceedings be kept in abeyance. For the simple reason that there is no multiplicity of proceedings, for the simple reason that if this honorable bench or any other bench where matter may go, may not go, were to allow my petition and set aside the order of remand, then the proceedings of ED are not over. It will have to be kept pending. Please have a look at the judgment at para 7, page 7, para 20.